We're excited to welcome two experts from Deckert today. Sonia Giuseppe, a partner in the San Francisco office, and Derek Manners, an associate in the DC office, to discuss the landscape and landmines around political contributions and the SEC's pay-to-play rule for advisors, as well as requirements around advisors' interactions with state, city, and county pension plans across the U.S. when you're providing or seeking to provide advisory services to these plans. As you may know, the SEC continues to focus on the pay-to-play rule. Last September, the SEC brought several enforcement actions against advisors where employees made political contributions that were prohibited of $1,000 or less, including a contribution of just $400, and that violated the strict liability provisions of the rule. In addition to SEC fines, violations of the rules can also result in disqualification for serving as an advisor to certain clients. Our expert panel has done a terrific job of putting together resources for you. In addition to the PowerPoint slides, there's a link to a Deckert alert from May of 2023 on preparing for the 2024 elections, pay-to-play, and other considerations for managers of public pension plan assets. So turning to the agenda, and there's our wonderful speakers. There's a link, and you'll get a copy if you haven't received it yet of the PowerPoint to the memo. So today we're going to cover the requirements and practical considerations around the SEC's pay-to-play rule for advisors, state and local procurement lobbying restrictions, which affect your firm's interaction with pension plan employees, rules and considerations around gifts and entertainment policies and procedures, and finally, we'll look at state and local placement agent rules, which could cover activities by your advisory personnel. So Sonia, thank you to you and Derek for joining us today. And Derek, I will hand it over to you.
Terrific. Thanks, Monique. So we're going to start today with the federal pay-to-play rules, and specifically Rule 20645 under the Investment Advisors Act. That's the rule that will be predominantly relevant to the IA's members. However, we have listed here the other federal pay-to-play rules, including MSRB Rule G37, which applies to municipal advisors, and FINRA Rule 2030, which applies to registered broker-dealers that an investment advisor may hire as a third-party placement agent or may have an affiliated broker-dealer who acts as a placement agent for the investment advisor. Rule 20645 has been around a while. It's been around since 2010, following some fairly high-profile scandals involving pension plans and political contributions. It has a very broad application. As Monique said, it's a focus of SEC enforcement, and seems every election cycle there are more exemptive applications for advisors seeking to not be subject to the restrictions despite a footfall, as well as enforcement action. So if we can go to the next slide. So broadly speaking, Rule 20645 has three main components. So the first one prohibits an advisor from providing an investment advisory services for compensation to a state or local public pension plan or other government entity for 2 years if the advisor or its covered associates make political contributions over a de minimis threshold, which we'll discuss in a little bit, but basically is $350 if the covered associate can vote for the covered official, and $150 if they can't. This only applies to certain officials who have authority over the government entity or officials who may appoint or influence such officials. So, for example, if a governor can appoint a member of a board of trustees to a public pension plan, then they would be considered a covered official. The 2-year prohibition on receiving compensation also has an anti-circumvention provision. So this comes up in a number of interesting fact patterns that we've analyzed for clients over the years. For example, serving on the board of an organization that has an affiliated PAC that makes contributions, and what you need to do around that to avoid circumvention of the Rule 20645. As Monique and I have noted, there's strict liability. So even though you don't have to intend for the contribution to influence the government official's decision-making with respect to hiring an investment advisor, you can still be found liable by the SEC for violating the rule. Next slide. As Monique mentioned, there were some recent enforcement actions last September, which we've listed here. And as Monique alluded to, none of these were particularly egregious facts. They're sort of more routine footfalls. In some cases, the advisor even found the violation themselves and reported it and were still dinged, as you can see. So this is an area where it's easy to have an accident where people may not be thinking about who exactly is a covered official or may just not realize that certain of their activities can trigger the rule. On the next slide, we'll talk about some of the broad takeaways from these enforcement cases. So as we've noted, it's an area of continued SEC focus. You don't have to have an intent to actually influence. In particular, what's a little odd is that you don't even have to be soliciting them for new business. So if you have an existing client who's a U.S. State or local pension plan that you've been doing business with for a couple of years or a number of years, and you're not seeking new business from them, even if you have a contribution that violates Rule 20645, that still is considered a violation, even though you're clearly not seeking new business from them at the time of the contribution. In addition, even returned contributions can still violate the rule. There is a very narrow return contribution exception, which we'll discuss in a little bit. But basically, if you can't fit within that, even if you get the contribution return, if it still violates Rule 20645, the SEC has brought enforcement actions. The other interesting piece about Rule 20645 is that because of the way some of these investments are structured, the government entity may not be able to withdraw their investment. And so essentially the advisor's stuck providing them free services until the end of their investment because they can't actually receive compensation. So it's an important rule that can implicate millions of dollars or as well as headline risk and a really annoying exemptive relief process that we'll discuss in a bit. Because of this, Commissioner Peirce and others have really raised a lot of concerns about the broad applicability of the rule and how it's, really in some ways not fair, particularly given the First Amendment rights that people have to participate in elections. Next slide. So what is a government entity and who are its officials? This is obviously an important thing that we'll talk about for practical considerations, but you need to understand what potential clients or investors in your funds are covered. So a government entity includes all state and local governments, agencies, and instrumentalities. It includes things like 529 college savings plans, and it applies to the officials, agents, and employees of these governmental entities. As I noted, it's state and local. So federal governmental entities, for example, the railroad employee retirement system for at the federal level isn't covered as a government entity. However, an official could include a federal official, which we'll discuss in a bit. So an official is any person or an election committee thereof, meaning even if they're just a candidate, even if they don't hold the office, even if they lose the election, if you donate to the election committee of somebody running for a covered office, then that still is picked up by Rule 20645. As I noted, it matters both what position they are currently in. So for example, if they are the governor running for a federal office, the mere fact that they have the ability to influence somebody in their current position, even if you donate to their federal campaign, that's still covered by Rule 20645. The reverse is also true. If you have a sitting US senator who has no ability currently to influence the outcome of an investment decision, if they're running for governor, then that would also be covered. So for example, the West Virginia senator is running for West Virginia governor at the moment. And so therefore they would be considered a cover official under Rule 20645. There are all these interpretive questions that if we have time, we can get into later if people have questions, for example, like are state legislators covered, city council members, et cetera. But for now, I want to move on. So what is a contribution? Obviously, everybody knows that a political donation to a campaign is considered a contribution, but the term is broader than that. It can also include in-kind contributions, which we'll discuss in a bit, and it can also include contributions to PACs or political parties if there are specific factors that could trigger the anti-circumvention requirement of the rule, where, so for example, if it's a single candidate PAC that only donates contributions to a single candidate, you wouldn't be able to give a contribution to that PAC and then say, oh, well, I wasn't donating to the candidate if the only candidate that PAC supports. If that candidate, if that PAC only supports one candidate who happens to be a covered official. Next slide. So as I mentioned, in-kind contributions can also count as contributions. So volunteer work can be considered a contribution if the advisor is involved. So for example, if an employee is using the advisor's resources, that can count as a contribution. So a lot of firms have political activity policies that sort of regulate what individuals can and can't do, for example, during work hours, or what committees they can be a part of, and seeking a pre-approval from compliance to make sure it doesn't trip up any of these rules. And this has been an area of enforcement as noted on this slide. Next slide. So who is a covered associate? This can be a complicated question. That's why a lot of firms will just prophylactically require anybody to pre-clear political contributions. We've included the technical definition here. Of particular note is who is considered an executive officer. It's a very broad concept and can include presidents, VPs in charge of a principal business unit, for example, sales, administration, or finance. It can also include any other officer of an advisor who performs a policy-making function. And that can include people who are not, strictly speaking, considered supervised persons of the investment advisor. It may be people outside the organization, as we've noted here on the slide. Finally, in terms of covering off on the definitions, solicit for purposes of a covered associate means to communicate directly or indirectly for purposes of obtaining or retaining a client, in this case, a governmental entity client. Next slide. So one of the interesting things about the covered associate definition is that there's this look back and look forward concept in the rule. So for example, if you have a covered associate who leaves one firm and goes to another, the 2-year timeout under the first prong of the rule would continue even after the person has left the firm. Similarly, if that same person goes to a new firm and isn't a covered associate, then that same 2-year timeout would follow them to the new firm and taint the new firm. So this is one of the things that you need to consider when you're hiring somebody, as well as when you're making promotions or engaged in M&A transactions with another advisor. This is making sure that you don't accidentally trip up Rule 20645. You also have to have a 2-year look back for somebody who's promoted as a covered associate. But there is an exception if the person is not going to solicit any clients, which means government or non-government clients. In a lot of cases, somebody who's a covered associate who is promoted, that's an untenable position. So a lot of firms will have a list of people that they think may be in these roles in the future. And so they'll have them pre-clear their contributions to ensure that this doesn't become an issue if and when they get promoted. This is also why a lot of firms make a large swath of people pre-clear their contributions, even if they're not technically considered covered associates under Rule 20645. Next slide. So the second part of Rule 20645 is a restriction on solicitors. So an advisor can't pay any person to solicit government business on their behalf unless they're a regulated person. Regulated person includes another investment advisor, includes also broker-dealers, as long as they haven't made a violative contribution under similar pay-to-play rules. Next slide. Finally, there's a prohibition on coordinating, bundling, or soliciting contributions. So if you're not familiar, bundling or being involved in fundraising, a lot of campaigns will have people who go and solicit other people to make contributions, and so they'll bundle a number of contributions together. And so the rule prohibits an advisor or its covered associates from doing this. And it also prohibits payments to political parties where the advisor is providing or seeking to provide advisory services to a government entity. It's an interesting issue. This happens a lot for fairly wealthy people who run in, those kind of circles where they can really get a lot of bang for the buck in terms of calling their friends and neighbors. And so this is something that a lot of founders or high up people in an organization may have to contend with if they want to serve in this role for our campaign. Next slide. So we'll touch on this briefly, but essentially there are differences in the way different products are treated under the rule. So in particular, registered investment companies are not subject to the 2-year timeout, except that if a registered investment company is going to be one of the investment options, for example, on a 529 plan, then it would be covered by the rule. And so one of the things you have to analyze when you're looking at this rule is what type of product that you're trying to get the governmental entity to either invest in or to put on their platform, or to be or if it's an SMA client, that would also be covered. So you have to consider the type of product that you're trying to get the government entity to be a part of. Next slide. So as I mentioned, there are some exceptions. The de minimis exception applies if a 2-legged individual can vote for the person, they can donate $350 or less. And if they can't, they can donate $150 or less. As we noted earlier, even a $400 contribution has led to enforcement action. So these limits are very strict. The one good thing is that these limits are separate for the primary and the general election. So for example, you can make a $350 contribution to somebody you can vote for in a primary, and then again, a $350 contribution for the general election. Super PAC contributions are unlimited. With that said, a lot of organizations will get a representation letter from a super PAC indicating that it's not intended to be an anti-circumvention of Rule 20645, and a lot of super PACs have those type of standard letters, and a lot of organizations develop their own letters that they use in order to have documentation that they're not circumventing the rule. As I mentioned, there is a narrow exception for returned contributions. So if you make a de minimis contribution, i.e. less than $350, but you're not actually entitled to vote for the person, so you thought you were, but you actually weren't, then if the contribution is returned within 60 days of being discovered, which it needs to be discovered within 4 months, then you can have the contribution returned and it doesn't count as a violation of Rule 20645. The frequency depends on the size of the advisor, how often you can use this exception. And again, this is a pretty narrow exception to begin with, so it's not something that a lot of firms are able to take advantage of, unfortunately. Next slide. As I mentioned, the exemptive relief process is long and expensive. We've included the relevant factors here. And in the next slide, we actually have an example from BlackRock's exemptive relief from 2018. And we have laid out some of the facts and some of the considerations that the SEC noted in granting the exemptive relief. The main thing to highlight here is that having an already robust compliance policy around this stuff will give you the cover to be able to get the exemptive relief. If you haven't put thought into this and you don't have a strong compliance program that deals with this, and it's just a simple issue of a footfall, then it's harder to get the exemptive relief from the SEC. And also of note here is that the contribution in question here was for John Kasich, who was running for president, but he was the current governor of Ohio at the time. And so again, this is one of the most common footfalls that advisors make, is having a covered associate make a contribution to a state and local official who is running for federal office, because people don't think that the federal office is covered, so they just don't even think 20645 applies. Next slide. So here we have, again, just some of the highlights that we've been talking about. You want to you want to analyze the covered official based on their current position, not just the office that they're seeking. It doesn't matter whether they win. As we've noted several times, this rule is very strict. And so if you violate it even just a little bit, you're subject to SEC enforcement and the application of the rule. So we've noted here a few other exemptive applications where there's very small contributions and the amount of fees that are at stake. So this is a very serious issue, even though these contributions can be relatively small. And I think with that, I think we're ready for the next part of this. I'll turn it over to Sonia.
Great, thank you, Derek. So I'm going to talk about practical considerations. And one reason why we chose the state to do the webinar is, in fact, because we are right in the middle of a new election cycle. Election day is coming up. So we'll be getting more and more information about people running for office, and people in turn will be making contributions. As Derek noted a few times, there's a common footfall, which is people with in a state office or local office that are running for a federal seat. And again, it does apply. So we do have the current governor of Florida running for president. So a contribution to his campaign would potentially taint an investment by one of the state plans in Florida for which he appoints the board or part of the board members. And there's also the governor of West Virginia running for a Senate seat, which again would taint those positions for which the individual may appoint people to the board of the state pension plan. Something that you should definitely consider when you're looking at this now and on an ongoing basis is who is a covered person. As Derek noted, it does potentially have a look back in the rule to people who were promoted to a position. So this is why, a lot of times clients do just do a blanket covering of their policy. It's slightly odd to say, hey, I'm going to put you as a covered associate because you may get promoted in the next 2 years, and then maybe don't promote them. And then again, you also want to identify who we're talking about here. Who are the government entities that are applicable to your organization, which is both the current investors who are government entities, as well as those who may potentially be government entities in the next 2 years. Next slide, please. And this is something else that Derek alluded to, is that this is not just a policy in a box. It has implications throughout the organization, and definitely HR and the personnel department should be aware of this. It comes up in many places, including prospective hires, promotions, as well as making sure that departing employees didn't make a contribution that you were unaware of. But then the counterbalance to this is that there are employee privacy rights, First Amendment considerations. I think this is heightened with respect to the hiring process. So it's no good answer here, but just something to be sensitive about and to be aware of. You also would want to monitor state and local laws, because while we focused on the SEC pay to play rule, there are other rules that may exist at the state or local level, and you wouldn't want to unnecessarily trip up, say, a law for the state in which the pension plan is located in. The good news is here, though, that most of these laws are not any more onerous than the pay to play rule. So you don't really have much to be concerned about, but then again, there's always the sleeper law that you don't want to unnecessarily trip up. Definitely, obviously advisors need to have policies and procedures on the pay to play rule. However, it is good, as Derek noted, to have a very robust program here, given the fact that a minor contribution of $100 or a few $100s may result in millions of dollars of fees not being collected for a couple of years. And then, just consider whether pre-clearance is necessary for any contribution. So you don't have people making judgment calls, which may be incorrect judgment calls as to what contribution is or is not covered under the policy. And then consider whether, periodic questionnaires are necessary. including whether or not these should just be sent out to employees on an ongoing basis, where they certify that they have not made any contributions in that applicable year or quarter. Next slide, please. Related to this would be having training programs. Definitely it's important to have real life examples so it sticks in people's minds as to what they can and cannot do or issues they should be thinking about. Definitely want to make sure that you have record keeping processes in place to keep track of both the training programs and monitoring of employees and how you are ensuring compliance overall. And then it's a good idea, and this is also something that has been highlighted in the exemptive applications or relief given about the use of technology in monitoring political contributions. There are a couple of websites that are free to use. The Federal Elections Commission has a website. There's also opensecrets.org. That is a website where you can go on there, put in anybody's name, and see if a contribution has been made. And then there's also systems that are out there that will proactively go out and do searches of these websites for you. And so with that, I will conclude and turn it over to Monique.
Great, thank you. That was an excellent description of the challenges and considerations. One question that I imagine comes up a lot is how are spousal contributions considered when you're analyzing a covered associate and the dollar amount. So does the employee's spouse count when you're looking at this rule?
So the short answer is generally no, but you have to worry about anti-circumvention. So, what you don't want, for example, is for a check to be signed by, a husband and wife or, two spouses that really is intended to be a contribution from the non-covered associate partner. And so because of, these sort of technicalities, some firms, in an abundance of caution, or where a spouse may be very politically active, in particular for a high profile member of their team, some firms do take the prophylactic step of including spouses in their covered associate analysis. But technically speaking, from the rules perspective, spouses are not covered unless there's some sort of indication that there's anti-circumvention or that the spouse is otherwise involved in the contribution.
Great. And then I've heard both of you say that most firms are requiring pre-clearance of political contributions. That was my question for you. Is that what you're finding in firms adopting policies and procedures here?
Well, I would say that there's a wide range of things that people do in this space. And so, for example, some people who are not currently seeking government investment, they will just, allow people to make contributions. And they know that at some point, if they start to seek government business, then they will, need to, go and check and make sure that they don't have any contributions that violate Rule 20645 before entering into those types of contracts. In addition, some firms, because they know, for example, that they are politically active in the tri-state area in New York, New Jersey, and Connecticut, they know that they won't solicit government investments from those states, but they'll solicit them elsewhere. And so they will not require pre-clearance of contributions to people running for office in the tri-state area. Other people do pre-clear just a very narrow set of covered associates. So they really analyze all of their personnel and see specifically who would be picked up by the rule, which I can tell you can be a little bit painful and a little bit expensive. And so other firms, and I would say a lot of firms, maybe not the majority, but certainly maybe the plurality, do just prophylactically require the lion's share of their personnel to pre-clear contributions.
That's great. Thank you. Okay, well, I wanted to share our first CLE code word. It's autumn, AUTUMN, autumn. And keep track of that. We'll have another code word at the end of the presentation for your CLE certification. So let's turn to procurement lobbying, and Sonia is going to walk us through this challenging area.
Great, thank you, Monique. So I've been working in this area for a while now, and the one thing I always tell clients before we get into it is that I apologize because these rules are just crazy. It doesn't make sense why they even apply to asset managers, and you're basically taking a regulatory regime for one particular type of industry, which is lobbyist, and applying it to asset managers, which the rules, the application, the definitions just don't always make a good transition, and nor is it easy to understand or follow. So just a note about what is procurement lobbying. This is distinguished from legislative lobbying, which is what you would think of when somebody goes to Congress or to the state legislator and says, hey, can you pass this bill or don't pass this bill? Procurement lobbying is related to entering into a contract. And the contract could include potentially the investment of assets. So the contract to invest the assets either through an investment vehicle or an investment management agreement of a pension plan with an asset manager. The key thing here is that there are a lot of laws that we're talking about, and the lobbying laws apply on a jurisdictional basis, meaning that each locality, whether it's a city, a county, or a state, will have its own different laws. The laws are all varied in terms of what they say, how they apply, what the requirements are. And each jurisdiction will have its own registration process, and you register with a commission within that jurisdiction, which typically is the local ethics commission. And I'll give an example here just to kind of lay out how this works. So we'll take the city of Los Angeles, which has its own lobbying law that applies to the city of Los Angeles pension plans. This law is more of a trigger-based law, meaning that if you hit certain triggers with respect to your time of the individual contacting the pension plan, that individual may need to register as a lobbyist. The county of Los Angeles has its own lobbying law, which actually is somewhat similar to the city's law. However, the county counsel's office for the county of Los Angeles has taken a different interpretation and has said that the county ordinance does not apply to the LA County pension system. So there is no lobbying requirement with respect to having the county pension plan invest its assets. And then there's the state of California, which has its own separate law, which would apply to the state pension plans, which are CalPERS, CalSTRS, and the UC regions with respect to the retirement system assets. This law, unless there's an exception, would require an individual to register in advance of contacting the state pension plans. So as you can see, there is a lot of variation here and a lot of different requirements to think about with respect to each pension plan. And that's the one theme here, is that the laws are all different and they do vary. In addition to potentially triggering registration as a lobbyist, these laws may also regulate the behavior of the individual lobbyist, which can include things like gifts and entertainment and the amount of contributions that they make. So the political contributions may be a lower amount, and this could be even lower than what is in the SEC pay-to-play rule. And the gifts are also going to be limited in a lot of jurisdictions. For example, in California, you're able to give, or a public official may accept $590 worth of gifts from any individual during the course of a year, whereas a lobbyist may only give $10 per month to anybody in which they are registered to lobby. And this is a state law lobbyist, not somebody at the local level. So there are a lot of different issues here to think about. And then the other issue too, which potentially could have a big implication depending on how the comp system works at your firm, which is that lobbyists may be restricted from receiving contingent compensation. So I'll move on to the next slide. You know,
Before,
sorry.
before you go on, I just thought about this. This contingent compensation was a really big issue when this first came out. Have firms come up with methodologies and procedures to determine whether or not they're paying folks on the contingent compensation basis?
I would say that, it's nothing that will make anybody happy if your comp is tied to this, but it will just be pulling out the comp for that individual from being contingent at that point in time based off of the success of a particular plan. And the idea is that you're compensated in other realms. So it would be just a flat compensation, which is a solution. But if you're on the receiving end of that, it's not a good solution.
Okay, thank you.
Unfortunately. I think the better solution, though, which I think we can talk about on the next slide, is figuring out what the thresholds are to register. Because if you're not going to be registered as a lobbyist, then that contingent comp ban will not apply. So this is why it's really important to understand what the registration thresholds are, because certain laws, not all, but certain ones do have thresholds, meaning the number of contacts, the amount of time spent lobbying, the compensation that you receive for lobbying, or expenditures. And expenditures would include potentially, buying a plane ticket and the hotel room to go visit someone from a public plan. If you know that the number of contacts is, say, 5 in a month, that will trigger registration. With that knowledge, you can make sure that the individual just does 4 contacts in that month. So this is a very important aspect to know in advance of what the triggers are. So you don't even fall into this regulatory regime. And move on to the next slide. And related to this, there are also exceptions if the law is triggered. And these are also important to know. I will note that, generally speaking, most of these laws do have carve-outs for responding to an RFP, because that's deemed to be an open process. There's also usually some type of carve-out for speaking at a public meeting. So if the IR people go to a meeting before the pension plan board, before they vote on a contract, typically that would not be deemed to be lobbying activity. But again, jurisdiction dependent, and you're going to really need to know what the laws are. And then I'll move on. There is the prohibition on contingent comp, but we already talked about that. So we'll move on to the next slide regarding potential consequences of a violation, which, a lot of times people will ask me and Derek as to, hey, these rules are crazy. Do we really have to comply? I will never tell someone to not comply with the law. But I will note that the violations here, I haven't seen anything egregious in terms of a penalty, as in the pay to play context that Derek was just speaking about. However, I do think this is very important to be mindful of, because in addition to potential fines, there is just the overall reputational issue. And potentially if investment is down and the plan wants to get out, this would be a really good way for them to have a breach of contract claim and to rescind the contract altogether. So just something to keep in the back of your mind. I just not advise on violating the laws here, just given that this is a unique area of law, and the plans all do talk to themselves, and you just don't want to be banned from one plan and expect to have great business opportunities with all the other plans throughout the US. So moving on, just highlight on a few issues here for practical considerations. I'm not going to go over these, but if anybody attending wants to look at these later on, this is how we analyze the laws and how we think about it. So this is an important kind of checklist to think about in terms of if you're looking at a law yourself and you want to think about how it does apply. In addition, it's important to integrate this into your operations. So move on to the next slide. The key here is to really understand, particularly when there's a fundraising push, as to who is being talked to in terms of what are the pension plans that the IR team is reaching out to or potentially would like to reach out to. And then also, who are they going to meet with right now who have a current investment. Because, you know, IR people do their job. And if you have a good IR team, then they are selling the products. So maybe they are going to a meeting about a current investment that's held. But then if they're going to do their job, they're going to talk about other great investment opportunities with your firm. So, you know, you just want to be aware of any meetings or contacts with the public plans. You know, as we discussed, you really want to understand the laws and exemptions, tracking about who contacts. I would recommend having this as part of your compliance policies and procedures, and also putting it in part of the training program where you really make sure that people understand this law. Because again, it's just not intuitive. Nobody really thinks that an individual at an asset manager is going to need to register as a lobbyist for talking to potential investors. And then also important is just to send periodic reminders about this. And then I'll move on to the next slide. And then here, this one is, I think, a very important point with respect to record keeping. The thing I always tell clients is I can sit here all day and tell you what the law is today, but if we open up the newspaper tomorrow and someone is arrested, then more than likely, because these laws are reactionary, the law may change in that jurisdiction, or there may be some type of investigation of the board of that plan where there was the bad act that occurred. We've had this happen to clients where, you know, there have been investigations with respect to the board, and in doing so, the you know, attorney general in that particular jurisdiction reaches out to the various plans that have contracts with investment advisors and asks the advisors to provide information about contacts between the advisor's employees and the plan, and if anything was given. So just so that you have and maintain good records here to comply with this, I would say that you should always document any meeting that individual at your organization has with a pension plan, just so that you are ready and prepared. And then finally, you know, this is a very complicated area. It's mind-boggling how many different laws are out there, and we have developed a system here where we have a summaries that we've created of, you know, many of the pension plans jurisdictions throughout the United States, and we maintain a database for this. So if you have any questions and would like to learn more about this, feel free to contact either myself or Derek on this. And with that, I will conclude this section.
Thank you. That is a lot to think about. It is very complex. One question that has come up is, if a person registers with the state as a lobbyist, does it cover all the pension plans in that state, or is it per pension plan?
So likely the answer is no. You know, this is something that I was talking about earlier when I was giving the examples between the city, county of LA and then the state of California. But you're really going to have to look at the nitty-gritty details of a particular law. There's a couple states out there where it's the state law regarding, you would think, state pension plans, but then it also covers maybe not all, but certain of the local pension plans. Like it might cover a county plan for teachers. And then there's some random plans out there where it's not clear if they are at the state or local level or county level, such as say like a transportation agency. So it's really hard to give a hard, fast rule for this, just like all these, but I would say the answer there is likely no. But again, you need to really look at the law and nail down on the nitty-gritty details.
Great, well, thank you. So let's move on to gifts and entertainment, another area of interest in this space. So we'll turn it over to Derek.
Yeah, and Monique, I think we had one question in the chat from Nicole, and the question was whether a contribution to a federal campaign where the candidate is not currently a state or local official, that would not be subject to Rule 20645, and that is correct. So for example, if you make a contribution to Nikki Haley, who is not currently a state or local elected official, even though she previously was, or to Senator Tim Scott, who is a current sitting U.S. federal senator running for president, neither of those individuals would be considered covered officials for the law, for Rule 20645. So switching gears and going back to gifts. So gifts and entertainment is another area where there are a wide variety of laws. There are, believe it or not, some states where there are no limits on the amount of gifts that you can give unless you start tripping into bribery, which, doesn't have like a set number. Um, and so, and then there are other states or agency specific rules and regulations that consider a bottle of water or a pen with a company's logo on it to be an impermissible gift. So similar to lobbying, these rules vary wildly. Some pension plans have also adopted their own restrictions beyond the publicly available or state or local law. And so some of these are available on their website in sort of an ethics policy section. Some of them, though, are private, and an individual won't know until they start getting involved in the procurement process and either responding to an RFP or entering into a side letter where they're asked to certify compliance with a non-public rule that they didn't know existed. And so just being very careful about who you give gifts to and making sure that you have a thoughtful policy in place to ensure that you don't have any of these footfalls is really important. And in particular, you want to do your own due diligence to see if there's any laws or agency specific policies that apply. And then sort of as a backup, it's always good practice to ask the official to make sure that they aren't subject to any specific non-public ethics policy that would limit the amount of gifts they can receive. In addition to agency-specific laws, lobbying laws may place additional limits on gifts, which Sonia discussed previously. This is an area where headline risk is particularly relevant. So even if you don't violate a rule or a law, if the frequency or the nature of the gifts are considered to be lavish or sensational, then that can create headline risk, which in turn can also harm your reputation, as Sonia described, with other people that you may be soliciting for investment. We can go to the next slide. So again, the definition of a gift depends on the jurisdiction. So in most cases, it includes a dollar amount. It can also include meals and beverages, though there may be certain exceptions, for example, like a business meeting, as long as you're in attendance. But it really just depends jurisdiction to jurisdiction. And as I noted, sometimes even a cup of coffee or a bottle of water or a firm branded pen, parking validation, flowers. I mean, you would be surprised at the variety in terms of what's considered a gift jurisdiction to jurisdiction. Next slide. All right, so what do we do with that? All right. First and foremost, it's important to have compliance policies. You want employees to track the gifts and entertainment they're providing to public employees. And if you are fairly active in this space or you're active in jurisdictions where you expect there to be fairly strict gift limits, so most of the bigger states and then sort of more left-leaning states, although that's not universally true, there are some smaller what we would call blue states that don't have as strict of rules, and then there are certain smaller red states that do have really strict rules. So there's no hard and fast rule, but essentially if you're seeking government investment in a number of jurisdictions, you may consider pre-clearance. In addition, most firms have a general limit on gifts and entertainment, but when you're giving it to public officials, you may want to consider lowering your limit or again instituting pre-clearance beyond sort of your general gifts and entertainment policy. And then finally, you would want to institute a process to review expense reimbursements just to make sure that somebody's, hasn't not told you about something that could be triggered. This is important because, as I mentioned, a lot of times there are specific disclosure requirements or certification requirements as part of a procurement process involving a public sector pension plan. And so you'll want to have records to be able to quickly answer any disclosure or certification questions that are posed by the governmental entity when you get closer to closing the transaction. You also want to have training around this, and so making sure that people have extra sensitivity to public sector officials and providing them with gifts and entertainment, providing them real world examples about the headline risk. And there's a multitude of examples that you can find involving ski trips and construction loans and all sorts of things that the media picks up on. This is an area of heightened media focus, so and those examples tend to stick with people. I already mentioned record keeping, and then similarly, there are technology vendors out there that you can use to help you analyze your gifts and entertainment and your expense reimbursements. Next slide. I'll turn it over to Sonia.
Great. Yep. Placement agents. So typically we think of placement agents as those working with placing interest of a broker dealer or using a broker dealer to place an interest of a fund. What does this mean for advisors that aren't even in this space?
Yeah, so you said something very important, Monique, which is we typically think of. However, that is different from what the rules are. And for whatever reason, placement agents have gotten a bad reputation among certain pension plans. This is, I think, because there was certain scandals related to some of them. Personally, I think this is misguided. I think investment consultants wield way more power than placement agents do, but it seems that the investment consultants monitor their behavior better than certain placement agents. So this is the world that we live or find ourselves in now. So like Monique mentioned, typically we think of placement agents as a third-party broker dealer, but people are always surprised that it's actually broader. Again, going back to our common theme here is that you need to look at the actual policy or regulation of the particular jurisdiction, because that jurisdiction, either law or policy, may define placement agent broadly to include internal personnel of the advisor. So not even a registered rep if, say, you have an affiliated broker dealer, but actually the internal investor relations person of the advisor. It potentially could even include your portfolio manager who goes to a meeting to meet with the public plan. So again, you really need to be mindful of the definitions here. And then the other thing to note is that what it means to be a placement agent will differ based off of the particular policy or regulation that we're looking at. Some are just purely disclosure regimes, meaning that you just need to disclose that you use this person that is being defined, quote unquote, as a placement agent. Other policies or regulations may actually restrict the payment of contingent compensation, which gets back to the prior issue we talked about for lobbying, is how do you address that? And then finally, certain plans may actually ban the use of third-party placement agents. I'll put a little pin on that because some of these policies are drafted so poorly that you read it and it literally will say no placement agent, which means that you could never actually have an individual at the advisor contact the plan, which doesn't even make logical sense. But again, these are policies that may be adopted by a board of a local pension plan who has no idea about the asset management industry and maybe just the reps of, say, the teachers union or the firefighter department. So we're talking about people that are drafting policies for things that they don't necessarily know about. So you get a lot of odd and weird results. So it's important just to understand these requirements in advance, particularly in advance of using a third-party placement agent. And then, this is just one of many considerations to think about when interacting with public plans. We could spend all day talking about the various considerations, but the next slide just kind of has a high-level summary of certain things to think about, which is that, there may be plan asset rules and regulations of the state that apply. You may have to register with the state as a vendor. I know that's something that happens in Illinois, even if you respond to an RFP. The plan itself may have restrictions on it by state or local law, which it will then impose on the advisor vis-a-vis a contract, whether in the separate account agreement or a side letter to an investment vehicle, including prohibitions on types of indemnification, Freedom of Information Act disclosures. And then there's also ongoing disclosure requirements, which again, these change over time as there are different scandals that happen in various jurisdictions. One to note is the California Form 700, which if a plan in that jurisdiction in California elects to opt into this disclosure requirement, could actually require the disclosure of the personal assets of the portfolio managers as well as others who work on the account of that pension plan. And that form is actually, the completed form is subject to public disclosure. So that's something just to be mindful of. And then with that, I will turn it over to Derek to conclude.
All right, you're on mute, Derek.
Thank you. Yeah, so we're going to have similar themes here that we have had in some of the other sections. And so first and foremost, you want to make sure that you're talking with your investment relations and your sales team to track the public pension plan investors and prospective investors that you're soliciting or that you may want to solicit. And you'll want to analyze the applicable rules that will be relevant there just to make sure that you have the right documentation to be able to make any certifications or disclosures, and that you are, complying with any third-party placement agent bans that may exist. And so in that regard, you'll want to make sure any contracts with third-party placement agents, which, by the way, should note that generally speaking, third-party placement agent does not include an affiliated captive broker-dealer. But again, it's jurisdiction specific. So you just want to be thoughtful about this when you're figuring out who it is that you're going to talk to and what rules apply. But in any true third-party placement agent arrangement, you'll want some contractual protections. So for example, a representation and warranty regarding compliance with lobbying laws, with federal and state financial service licensing, representations about political contributions and the provision of gifts and entertainment to public officials, particularly when they're involved in selling your products. The last thing you want is a third-party placement agent taking somebody on a fancy ski trip to sell your product. You also want a notification provision where they will tell you about any pending enforcement action related to any of these issues. Because obviously if they are inviting scrutiny on themselves, then that scrutiny will come to you as well. And so you want to be able to at least know and be prepared to answer questions and to get your ducks in a row before a state or federal official, begins asking you questions. You also want to make sure that they provide you any information that you'll need to disclose. As Sonia briefly mentioned, a number of regimes require political contribution or gift disclosure or potential compensation disclosure for people that you've identified as placement agents, the asset manager. And so you, the asset manager, will have a responsibility to disclose information about the placement agent. So you'll want to make sure that you have the ability in the agreement to do that and to get the information you need to make those disclosures. And then finally, you want to make sure that any payments you make are in compliance with applicable laws. For example, the marketing rule, which has a disqualification provision for people that are making an endorsement, which a third-party placement agent would generally be somebody who's endorsing the advisor. And I think that's it. Okay,
great. Anything you wanted to share on this slide you probably already mentioned a lot of this.
Yeah, exactly.
Okay.
The only other thing I'd mention is that is that similar to lobbying, you just want to be mindful about who you have involved in government contacts. And so a lot of firms will limit the people that are speaking to these to a handful of people, so that keeps the disclosure and certification process for compliance with lobbying and other laws to be more easy to comply with if you've got a smaller subset of people. That's the main thing.
Yeah, great. Well, thank you. That was an excellent presentation. We are at the end of our webinar today. I wanted to share the last code word. It's pension, PENSION. If you had any further questions for our panelists, please email us or let us know. We'll be happy to get back to you. Thank you, Sonia and Derek, so much for joining us today and providing this helpful guidance. It's very complex, and we really appreciate you joining us. And please take a look at the World Compass and also the memo that Deckard has provided. Also, please fill out the evaluation that you'll receive this afternoon. If you're seeking continuing legal education, that's where you'll log your code words. And that's it for today. Thanks everyone for joining us, and have a wonderful day.